supply credible evidence of an extraordinary wrongdoing and sufficient proof of the allegations against the Deputy President. Mr. Speaker, sir, distinguished senators, we submit that is where the mover of this motion ought to start having problems with this House when he's called upon to account. It is the submission of His Excellency Rigathi Gachagua that the motion now before you has a threshold set by law by multiple miles. When you examine the material before you, you will discover that it will oscillate between the following categories of stages. One, you will have material before you that just plainly false. Then from falsehood, it will go to the ridiculous ones, and I'll demonstrate that shortly. There will be ridiculous claims here. Then finally, it will end up into embarrassing claims. Allow me, in the few minutes I have, to just do a snip preview of some of these claims so that we have an overview of the case that is before you. At paragraph 74B of the first volume, which is the impeachment motion, you will find an allegation of this nature that His Excellency Rigathi Gachagua has influenced his family members, allies, associates, and proxies to take control of a local cooperative society in Madeira, which they are financially hemorrhaging. Number one, no name of any family member is supplied in the allegation or in any of the evidentiary documents before you. No name of any ally is supplied in the motion or in any of the documents before you. No name of any associate is supplied, even a false name, none, is supplied in the motion and in the documents before you. No name of any proxy is supplied in the motion or in any of the documents before you. The name of the alleged circle is not identified. You can imagine, Mr. Speaker, sir, distinguished senators, being called to defend yourself on a claim that you have taken over through your associates a circle that we don't know. Told, now come and defend yourself. I began by saying some of these claims are either ridiculous or embarrassing. Secondly, at paragraph 74A, you'll be told that His Excellency has connived with cartels in the tea sector to block the Kenya Tea Development Agency from implementing guaranteed minimum returns that would benefit tea farmers. No statement, no affidavit, no correspondence from any official of the Kenya Tea Development Agency is before you. No complaint to any agency, no complaint to this parliament by any official of the Kenya Tea Development Agency is before you. It's just a claim which the mover of this motion said before the National Assembly, and surprisingly, to those of us who have some residual faith in our institution, he told the National Assembly, just believe my word for what it is. And when we thought that was a joke, we got a joke lifted a notch higher. The National Assembly actually just believed his word for what it is. No evidence. Nothing in the affidavits before you addresses anything about the Kenya Tea Development Agency. Nothing in the 5 affidavits before you. Let's progress, good people. Paragraph 72 of the motion before you states that His Excellency has persistently undermined, demeaned, and committed insubordination instead of assisting the President. And let's face it, Mr. Speaker, sir, distinguished senators, if you accuse somebody of insubordination, the only person who can complain of being insubordinated is the supervisor. No statement from the President, no affidavit from the President, even no witness summons to the President has been sought here to call him to complain he has been insubordinated. The Deputy President, when he received this motion, wrote to the Secretary to the Cabinet, requesting to be supplied by all assignments given to him by the President and any that he has not delivered. To date, as we stand here, we have not received a response to that letter. And yet we shall be told, just believe the mover of this motion, the Member of Parliament for Kibwezi West constituency, that when he is oscillating between the National Assembly and Kibwezi West to serve his people, he knows better than the supervisor of the Deputy President that the Deputy President has insubordinated his boss. I began by observing they will move from the false through the ridiculous to the embarrassing, and these are the claims before you. At paragraph 64, paragraph A of the impeachment motion, you will be told that His Excellency the Deputy President said that he would present a petition for the removal of Justice Esther Maina from office, which he has not done to date. Mr. Speaker, sir, my eyes are normally problematic, so I will not know the time allocation.
15 minutes.
Thank you so much, Mr. Speaker, sir. The claim is that His Excellency publicly said that he would present a petition for the removal of Justice Esther Maina from office, which he has not done to date. That's the complaint. Evidence is before you that there is a pending complaint by His Excellency, the Deputy President, before the Judicial Service Commission. So the mover of this motion first has perjured himself in his affidavit by saying that each of these facts are correct, when this fact is false by evidence available. You will find that paragraph 34 of the motion before you, it says that His Excellency falsely threatened to file a petition for removal of Justice Esther Maina. How can the Deputy President be accused of falsely threatening when in fact he has filed the complaint? Where is the falsehood when there is a pending complaint? That complaint is before you in the Deputy President's documents for your own perusal. I began by saying they'll move from the false through the ridiculous to the embarrassing. At paragraph 78C, you'll be told that His Excellency routinely summons procurement officers in ministries and state institutions and instructs them to direct procurement of goods and services in a specific manner. No officer from any ministry will swear an affidavit claiming to have been summoned to award any procurement for any goods or any services in a particular manner. In fact, what you'll have before you is actually very ridiculous. You will be told that there was a tender for supply of mosquito nets that was cancelled in May 2023. Then a local company that was an agent of the supplier was following for the return of its bid bond in July, 2 months after the cancellation of the tender. How can you influence a tender that was cancelled 2 months ago? I told you it will move from the false through the ridiculous to the embarrassing. Now, the more interesting one is at paragraph 78A. You will be told that His Excellency bullied Kenya Medical Supplies Agency officials into awarding a tender for the supply of mosquito nets to Crystal Limited. Good people, Crystal Limited was not even a bidder for that tender. He pressurized people to award it to somebody who is not even a bidder for that tender. I observed it will move from the false through the ridiculous to the embarrassing. Those of us who understand this motion for what it is, understand why these panel beating maneuvers are being tried here. The motion as presented and approved by the National Assembly will remain in our constitutional history as the most embarrassing motion ever approved by a House of Parliament in the Commonwealth. We respectfully submit. You'll be told at paragraph 58 that His Excellency is reasonably suspected to be the principal beneficiary of what are called dubious transactions by Lusona Events Limited. You will then go to the allegations on Lusona Events Limited, and you want to see those transactions, how are they terminating to the deputy president? You'll not come across any connection. They'll just say, a director of this company withdrew some money from his own company. The deputy president is a director. None of his family members are director. That person withdrew money from his company, bought a motor vehicle in his own name. The mover will say, I'm therefore drawing a reasonable conclusion that the deputy president is the beneficiary of this. Good people, the word reasonable has meaning known to law. I submit very respectfully that this falls short of the definition of the word reasonable suspicion. I submit it actually gravitates towards unreasonable suspicion. Now let's look at this. You'll be told that His Excellency has acquired 40 acres of land in Kakuret, Kamburaini in Nyeri. Evidence before you will show that this is land that the deputy president in fact bought from a current member of the National Assembly. So he knows that member. In 2015, before he even joined state office as a member of parliament, you are told that the purchase of this land in 2015 shows that in the last 2 years, the deputy president has amassed immense wealth. I began by saying, let's be elementarily decent. One of the most frustrating things about preparing for such a hopelessly conceptualized, hopelessly crafted, and hopelessly presented case is that you begin doubting yourself because you begin wondering, what am I not seeing? Land bought from a sitting member of the National Assembly in the year 2015 is supposed to be evidence that in the last 2 years, His Excellency Rigathi Gachagua has amassed immense wealth from the office of the president to acquire that property. Now, let's look at paragraph 45G. You'll be told that His Excellency has acquired 80 acres of land in Meru County. No land registration number is provided. Not even an affidavit of a neighbor who says, I know yes, this land is my neighbor. Just an allegation by the mover of this motion like that. And the Swahili say, ukistaajabu ya Musa utaona Firauni. This mover of this motion stood before the National Assembly and said, just believe me for this statement as it is. The first joke. The second joke, the National Assembly actually believed him and approved the motion. You'll be told that paragraph 45H, that His Excellency has acquired a dairy farm in Nyandarua County. Now, I guess we all have a common understanding of what a dairy farm is. His Excellency has no dairy farm in Nyandarua County. The move of this motion does not give us any evidence of this dairy farm in Nyandarua County. You'll be told that His Excellency has used the office of the Deputy President to corruptly influence unnecessary and expensive renovation of his official residence in Karen and Mombasa. What will shock you is this, good people. The contract for the renovation of the official residence of the Deputy President was signed by the controller of State House. Unless the move of this motion wants to make a claim that the Deputy President conspired with the State House to have this contract executed. Number two, it will be known to all of us as members of Parliament that the money for renovation of this official residence was approved by the National Assembly. Is the National Assembly conceding that it approved money for unnecessary expenditure by government? How can the National Assembly approve money for use for renovation of the residence of the Deputy President, then after that money is used for the intended purpose, the renovation of the official residence of the President, now drag the Deputy President for impeachment for the reason of that renovation? I said, It will move through the ridiculous to the embarrassing. You'll be told that the deputy president has a helicopter landing facility at his land, Ruguru, Kiamariga, 1223 in Madeira. The deputy president simply has no helicopter landing pad on that farm, a small parcel of land with napier grass, unless the mover of this motion can now convince us that new technology has emerged, that napier grass is the constructing material for landing pads for aircraft. That's the only way it can make sense. But because it doesn't make sense, good people, you'll agree with me, it moves from the false through the ridiculous to the embarrassing. Now let's deal with it. You'll be told the deputy president has amassed a wealth portfolio amounting to 5.2 billion shillings. Elementarily, we must then look at the particularization. Tell us which one is what plus which one is what plus which one is what to amount to this 5.2 billion. This figure, the origin, is only known to the mover of this motion. There is nothing on the body of the motion. There is nothing in the documents attached. Mutuse throughout. And for the benefit of the senators, we were actually contemporaries at the university many years ago. So, Speaker, as they are setting up the witness administratively, I beg my time be paused.
Proceed, Counsel.
Thank you. Honorable Mutuse, before being a member of parliament, what is your professional background?
I am a lawyer.
You're a lawyer by profession. You therefore understand the substantive laws and the procedural laws of this country. Is that a fair assessment?
Yes, it is.
I would take a few minutes examining you, then I will release you to my learned colleagues, Mr. Swanya and Mr. Masharia, to take you on a number of issues.
But allow me to start with the issue of Justice Esther Maina.
You are aware, being a lawyer, that by law, you are bound by the allegations you presented to the National Assembly. Are you aware of that?
Yes, we are bound by the allegations in the context of the rules of the Senate and the other laws.
To deal with the issue of Justice Esther Maina, allow me to take you to paragraph 64A of your allegations, and that would be volume 1 of the National Assembly documents,
Page 32. I have it. Do you have that allegation?
Yes, I am there.
The allegation says that sometime in January 2024, His Excellency Rigathi Gachagua made a sensational but false allegation that Honorable Esther Maina, judge of the High Court, had engaged in corruption. He publicly said that he would present a petition for the removal of the said judge, which he has not done to date. It is your allegation that Honorable Rigathi Gachagua has not presented this petition to date, being 26th of September 2024. True or not true?
This is in context.
True or not true? Is it true that your claim says he has not presented that claim as at 26th?
True.
Do you still stand by that part of your allegation that he has not presented that complaint to the JSC to that date?
I have since learned that indeed.
Do you still stand by that allegation?
I have since learned that indeed His Excellency Rigathi Gachagua did present a petition, but
Do you still stand by the fact that he has not presented the claim to the JSC as at 26 September 2024?
I have since learned that he did present a petition.
To that extent, that allegation is not true. Yes?
To the extent of presenting the petition, but to the extent of threatening the judge.
To the extent that you say he has not presented the allegation to the JSC to us at 26 September 2024, that allegation is not true, is it?
We are in agreement, Counsel.
Thank you. You therefore understand where we start from by saying it starts with falsehoods. Do you understand that?
That's you saying so.
As whether you understand it. You have drawn the attention of these senators to the judgment of Justice Esther Maina, haven't you?
I have done so.
Your intention of doing so is to have these senators draw an inference of acts of corruption on the part of His Excellency. True or not true?
Is to buttress.
Thank you.
My allegation that Justice Maina had made a finding against the Deputy President.
Did you attend the hearing of that case?
I do not have to attend. It is a reported case.
I've asked whether you, in fact, attended. Please answer my questions. You know the process.
I did not attend. And there is no...
His Excellency, in the clip you have played, says that the judge denied him a chance to cross-examine witnesses. Did you see that in the clips?
Yes, I did see.
Did you have any evidence to the contrary, that the judge didn't deny him?
See, if you are denied...
Do you have any evidence to the contrary? Either you do or you don't.
And that is not my allegation.
My question to you is, do you have any evidence to the contrary? Answer my question.
But the truth is, that is a judicial process.
Do you have any evidence to the contrary when His Excellency says the judge denied him a chance to cross-examine witnesses?
I do not have to.
Do you in fact have it, Mr. Mutuse? Please be decent as a lawyer, a lawmaker, and a witness before this House.
I do not have...
Honorable Mutuse,
I do not have
questions that you either say yes or no.
Thank you. Thank you.
You then say you are aware that there was an appeal from the decision of Justice Maina. Do you confirm that as a fact?
Yes, I am aware that there was an appeal that was...
I'm happy with that answer. Let me make progress. That appeal was settled by consent. True or not true?
True.
Is a consent a lawful way of settling disputes in court, to your knowledge as a lawyer?
It is a lawful way, but it is not a settlement.
You have answered my question.
I am by merit or demerits.
Is a consent a lawful way of settling court disputes before a court of law?
It is a lawful way.
Do not hold any water. So during the morning session, we had a recap of what happened yesterday. where senators were given some time to seek clarifications from witnesses. The witness in chief, that is Honorable Mwengi Mutuse, who is the mover of this motion, as well as the former KEMSA CEO, Dr. Andrew Mulwa. And immediately after that, the House proceeded for a lunch break, and we are resuming this afternoon to commence the second part of this hearing, where the Deputy President will be accorded a maximum of 2 hours for evidence of witnesses and re-examination. The National Assembly will then have a maximum of 2 hours for cross-examination. That will happen during this afternoon session, where the Deputy President will be telling senators why the 11 charges leveled against him, among the charges being undermining matters to do with devolution, undermining the presidency, and matters to do with gross misconduct. Why the charges are frivolous, baseless, as has been termed by his counsel. After the counsel for the prosecution here being the National Assembly, the team at the National Assembly, they are being led by lawyers, Honorable James Orengo being the lead counsel of the team, as well as lawyers such as Muthomi Thiankolu. And during the 60 minutes allocated by the Speaker, being the closing statement, the National Assembly will be having their final opportunity to convince the House why they should uphold the impeachment charges leveled against the Deputy President. Similarly, the Defense Counsel and the Deputy President of the Republic of Kenya will equally be accorded 60 minutes to convince senators, this being last-minute attempts to convince the House why the charges against the Deputy President should not be upheld, and why the Deputy President of the Republic of Kenya ought to continue being in office. After the completion of the closing statements by the two sides, we will be having a closed-door session by senators before the honorable members of the Senate consider and vote on the 11 grounds for removal from office. The Speaker of the Senate, Honorable Amason Jeffa Kingi, has already stepped into the chamber this afternoon. Allow me to hand you over for this live broadcast brought to you by the Parliamentary Broadcasting Unit in partnership with KBC. My name is Gladys Mungai. Enjoy your viewing.
Na tuombe. Ewe Mwenyezi Mungu, twakusihi tutazame kwa neema nyingi na baraka sisi watumishi wako ambao umeridhika kutuita kwa nyadhifa za uongozi katika jamhuri hii yetu. Twakuomba utuajalie tuyatende na kufikia mambo yote yatakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. Clerk, do you have quorum? Honorable Senators, please take your seats. We do have quorum, so we'll straight away go to this afternoon's business. Clerk, you may now call the first order.
Order number 1, communication from the chair. Order number 2, hearing and determination on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
We'll give time to ample time to parties so that they can adequately present their cases. Now, as of yesterday, the Deputy President had been allocated 3 hours. 1 hour was taken away for other businesses of yesterday and today. That is pursuant to a request by counsel for the Deputy President. And therefore, as we speak, the Deputy President will have 2 hours to present his case, and thereafter the National Assembly will have 1.5 hours because they've also consumed half an hour of the 2 hours that had been granted to them yesterday. So you had borrowed 10 minutes, you ended up consuming 20 more minutes, as per our record. Council, this is not a matter to debate.
Mr. Speaker, sir, I just wanted to clarify that we had borrowed 10 minutes.
Yes, you borrowed 10 minutes, yes, but you ended up consuming 20 more.
No, we did get that indication, Mr. Speaker. In fact,
now you're getting the indication.
Yes. We had budgeted our time knowing that we had 1 hour 50 minutes.
Consume the 1 hour and a half, and then let's see where that takes you, and we'll be able to engage when you consume the 1.5 hours.
We are most obliged, Mr. Speaker, sir.
Thank you. Senior Counsel Paul Mwite, if you're ready, you may usher in your witness.
Mheshimiwa Speaker, just to get clarification, I was under the impression that the National Assembly will proceed and close their case, and that then counsel for the Deputy President will now present the Deputy President, who is the only one that we are calling as a witness. And that thereafter, the National Assembly will make their closing speech, and we will have the opportunity at that time to also make our closing speech. So I would like to have clarification.
Very well, Senior Counsel. Maybe I'll read the whole program all the way to the end.
Thank you.
You will proceed. Of course, for the record, I will ask the National Assembly to officially rest their matter to allow you usher in your witness. Once your witness takes to the stand, you have 2 hours to present your case. The National Assembly has 1.5 hours for purposes of cross-examination. Thereafter, the senators will have 1 hour to seek clarifications or ask questions. Once that is done, the counsel for the National Assembly will have 1 hour to make closing remarks. Likewise, the team of the Deputy President will be given 1 hour to make its closing remarks. Once that is done, the Senate will move into a closed session as per our rules of procedure. So that is the program for this afternoon.
I'm now very clear, Mheshimiwa Speaker, and I thank you. The situation is now clear. But just before my colleagues on the other side close their case, can I, through Mheshimiwa Speaker, ask whether the National Assembly still wishes to call a witness whose affidavit was filed, the governor of the county government of Nairobi, Johnson Sakaja. We have a copy of his affidavit. Is he going to be called or not called? Because if the National Assembly is not calling that affidavit, whose affidavit is part of the record and was availed to us, that affidavit, Mheshimiwa Speaker, contains allegations that are extremely injurious to the Deputy President. So if he is not going to be called, we will be making an application for that affidavit to be expunged from the records of this Honorable Senate. Thank you.
Counsel for the National Assembly, you had listed quite a number of witnesses. Are you going to call all of them, or are you going to, for the record, are you going to close your case where we are?
Mr. Speaker, sir, on behalf of the National Assembly, we shall close our case where we are. Mr. Speaker, sir, if you are, with your permission, I could respond to the submissions by my learned senior, Mr. Paul Mwite.
Please do.
Mr. Speaker, sir, at the beginning of the proceedings that we are currently going through, this House did invite parties to give indications as to the witnesses they wanted to call. Mr. Speaker, sir, we gave the list of the witnesses whom we thought were relevant for purposes of clarifying what we needed to have clarified. If Counsel for His Excellency the Deputy President did not do as much or did not take advantage of that window that was open, surely they cannot blame us for it. But secondly, and more importantly, Mr. Speaker, sir, yesterday, in the course of the deliberations in relation to one of the preliminary questions that had been raised, you gave a very clear ruling on the intendment of Rule 20 of the rules of this House. In particular, the understanding was that every material that was forwarded by the Speaker of the National Assembly to this House constituted evidence in support of the allegations that are the subject of inquiry by this House. It then follows that if the application that learned senior counsel, Mr. Paul Mwita, is making were to be looked at in its totality, he is actually making an application to amend or to remove certain aspects of the evidence from the record. Mr. Speaker, sir, that is an issue that you settled and rested yesterday. I don't think it's an issue that is open for re-intervention. Mr. Speaker, sir, it should also suffice to note that even on our side, there are affidavits that form part of the record that came from the National Assembly. In particular, there is an affidavit sworn and which is in favor of His Excellency the Deputy President, an affidavit sworn by the joint executors of the will, that is Mr. Njoroge Rigeru, together with the other executors. It is part of this record. We have not made an application to have it expand. We have an opportunity to deal with it when the time comes. Lastly, Mr. Speaker, sir, the nature of the sittings that this House currently is undertaking is quasi-judicial. It is inquisitorial in nature. If that is to be the correct position, Mr. Speaker, sir, then the rules of evidence as we know it in the court would not necessarily bind the proceedings, because what has been presented is the subject of what the honorable senators are going to investigate. At the end of it, it is not a judgment that they will be giving, it will be a vote. I rest my case, Mr. Speaker, sir.
Senior Counsel Paul Mwita.
Mheshimiwa Speaker, first and foremost, the affidavits that my colleague, my learned friend, referred to were sworn by the executors of the will of the late brother to the Deputy President. They were filed in the National Assembly, in the proceedings in the National Assemblies. They were never filed here as affidavits of witnesses that we proposed to call. With regard to the affidavit of Governor Sakaja Johnston, it was specifically filed in the Senate, an affidavit of a witness that they intended to call. That affidavit has material injurious to the Deputy President. Mheshimiwa Speaker, we were looking forward to cross-examining Governor Sakaja so as to bring out the truth to assist this Honorable Senate to make a decision. If he is not being called, and in fairness to the Deputy Governor, all that we are asking is that affidavit be expurged together with the affidavit of Peterson Jomo, who they are not calling now, and also the affidavit of Mercy Wajau, who is not being called. It is not fair to file affidavits containing information allegations injurious to the other party, then ask that those affidavits to remain as part of the record without calling them and availing them for cross-examination. So my application is that the 3 affidavits be struck out. Thank you.
Mr. Speaker, sir, just for clarity, there is absolutely no new material that was presented after the material that was sent to this House from the National Assembly. For instance, the affidavit by His Excellency Johnson Sakaja is to be found at volume 1 of the documents that have been filed.
Maybe counsel for the National Assembly, let me get it clear.
Yes,
the affidavit by the Nairobi governor, was it filed after the proceedings of the National Assembly, or it forms part and parcel of the proceedings that came from the National Assembly?
It forms part and parcel of the proceedings that came from the National Assembly. In particular, Mr. Speaker, sir, all those affidavits form what constituted part of what came into through public participation.
So just hold on that so that we make progress. Senior counsel, you have indicated that the affidavit by the Honorable Governor for Nairobi did not form part of the documents that emanated from the National Assembly. Now, the position as held by the Council of the National Assembly is to the contrary. These are things we can settle now. Did it come with a bundle of documents from the National Assembly, or it was filed after the Senate was seized of those documents?
Mheshimiwa Speaker, I have been corrected by my colleagues. The affidavits where the affidavit by Governor Johnson Sakaja was actually part of the public participation. So it was part of the record of the National
So now,
yes,
let's move to the 2.
Yes.
Let's move to the 2. Now, have a seat, Senior Counsel. Counsel for the National Assembly.
Yes, Mr. Speaker, sir.
Yeah, respond to the 2 more affidavits, because the contention from the Council of the Deputy President is that they were filed after the record was received from the National Assembly by the Senate.
Mr. Speaker, sir, I reiterate the position that we earlier on gave, that there's not any single document other than the document that was admitted yesterday pursuant to our application that came in after the record had been presented before this House.
So the affidavits were not filed after the Senate received the bundle of documents from the National Assembly?
Absolutely not.
Can you lead us to the volume and the page containing these affidavits from the National Assembly?
Mr. Speaker, sir, just give me 1 minute to consult with my colleagues here. I identify it, then I bring it. It's not an issue that we had anticipated.
Yeah, so that we settle this matter.
Most of that.
Yeah, let's settle it.
It is not, Mheshimiwa Speaker, it's only the affidavit of Peterson Jomo that was filed in the Senate. It did not form any part
Very well,
of the National
Council.
Assembly.
So then let's settle that one and we make progress. We need not argue on this matter.
Mr. Speaker, sir, I think what happened is that we skipped the opportunity to identify the documents from both sides of what had been filed. The documents that we filed yesterday has a volume 8. That is the document that contains the affidavit of Peterson Jomo.
So it is that affidavit, if you go to the Senior Counsel, it is that affidavit that they're looking forward to cross-examining the deponent. Now that you've closed your case, the argument from the Council of the Deputy President is, how then are we going to test the truth of those averments? What say you on that?
Mr. Speaker, sir, I did give an indication that, number one, at the commencement of these proceedings, any party who wanted to cross-examine any of the deponents of any of the documents had an opportunity, upon your invitation, to invite such parties to appear before them. If our counterparts appearing for His Excellency the Deputy President did not find it appropriate to call that at that point in time, they cannot now hold us to say that you had said you'd call this person, you will not call them. Because the person we were to call was for purposes of clarifying what we thought was important for us. Now, this being an inquisitorial proceeding, a quasi-judicial proceeding, Mr. Speaker, sir, I think it would be a stretch to expect that if we didn't call or if we didn't avail any of the witnesses that were mentioned in any of the affidavits, then as of necessity that follows that record or that affidavit needs to be expunged. That's what I was saying. Pursuant to your ruling yesterday, that is evidence and material that was presented yesterday. It forms part of your record.
Now, before I give my way forward, Senator for Nairobi City.
Honorable Speaker, the counsel that are appearing in this case are people that I hold in extremely high regard. Senior Counsel Paul Muite appears to not have the confidence of the judges sitting here that we know how to treat evidence contained in an affidavit that is not tested at cross-examination. Even the judges you appear before in the courts that you practice in know what to do with evidence of a person who is not availing themselves for cross-examination. So, Honorable Speaker, I really don't understand what the contention is, because we sitting here as judges know how to treat that evidence, and I wanted to take this opportunity to calm the anxiety of Senior Counsel Paul Muite, that indeed we do know what to do with such evidence.
Now, so that we make progress, Senior Counsel has raised an important matter, which matter has been responded to by the Counsel for the National Assembly. Now, honorable senators, there is an affidavit sworn by one Jomo Mushira, who had been listed to appear as a witness for and on behalf of the National Assembly. The National Assembly has closed its case without calling that particular witness, and yet there's an affidavit that the Counsel for the Deputy President will not have an opportunity to cross-examine. The question, as you retire at the end of this hearing, is to look at the probative value of that particular document. Senior Counsel Paul Muite, your point is valid. The senators have noted.
Because this is an important, very important institution with a judicial function, court of record, permit me to put on record that there is a slight distinction between counsel and the client. I have absolute full faith in honorable senators, including my friend, the senator for Nairobi, but I am carrying out instructions of my client.
Yeah, so I've given direction on this particular matter. Let us move forward. Having said that, Senior Counsel Paul Mwite, if you're ready, you may now usher in your witness.
Mheshimiwa Speaker, we are anxiously waiting for the Deputy President. My colleagues can stand here, can stand in. For me, let me make inquiries and find out where he's held up. We certainly wish to call him as a witness.
Very well.